But the most important question that I've heard a judge ask is, has your dog stepped on a bee?
Yeah, that is the biggest.
Well, we're back. Episode 2 of the Lawish podcast. If you're still with us after episode 1, we appreciate that. Today we have a topic that is much lighter, much easier to discuss. Is friendlier, not to the parties involved.
Yeah.
But it's going to be a lot nicer for us to be able to discuss. There's a lot less writing on the line.
Absolutely.
And the topic today is, for those of you who have been living under a rock, recently there was a very publicized case, civil case, between two celebrities, Amber Heard and Johnny Depp.
Yeah, very high profile.
Very high profile, defamation case. We don't need to go into details of that. The interesting thing was that recently, maybe a week or so ago, Amber Heard's lawyers filed a motion for mistrial. And we'll go into what a motion for mistrial is later on. But essentially what the lawyers were asking was, hey, judge, set aside the trial, set aside the verdict, and we should have a new trial, according to them. Circumstances warranted a new trial because there had been a heinous situation that occurred with a juror. Intrigue. Anyways, so we're going to talk about that today. The court actually submitted the order, so now that's a done deal. But I think it's a really nice way to explore some of these legal topics that are not necessarily, seen every day. And the fact that this was a high-profile case, it lends itself to have a nice, short discussion about it. That then hopefully you can get some value out of this. The most natural way to do this is by starting with the voir dire process, which is essentially how you get jurors in the first place.
Absolutely.
So, Jeff, as an attorney and litigator, why don't you walk us through the voir dire process?
Voir dire is basically what's obviously commonly known as jury selection. It's just the process of picking a sitting jury for a jury trial, obviously. So you could have bench trial, which is in front of a judge, or a jury trial, which is obviously in front of a jury. So jury selection is really, anytime there is a jury trial, they're going to call a bunch of jurors.
That's when you get your jury summons in the mail that everybody loves.
Exactly. Everybody loves it. Everybody's super excited to do it. And,
I get to do jury duty.
Make that $10 a day or whatever, and pay more
sometimes
than that
there's
parking,
meals and they validate the parking.
It can be. And hey, sometimes the cases are interesting. Other times you don't even end up sitting on the case. But yeah, so they'll summon way more jurors than they think they're going to need. And that's because they don't know ultimately how many are going to get eliminated, prior to actually getting a jury that's going to be the sitting jury. So both attorneys, plaintiff and defendant, or the prosecutor and the defense attorney, depending on if it's civil or criminal, have an opportunity to ask the juror questions, go over the process with the jury, make sure they understand it, make sure they understand the importance of being fair and impartial, what's riding on the decision, why it's so important to be fair and impartial.
Which is truly the reasoning behind voir dire is to ensure that there's a fair process, meaning you will have a right to a jury of your peers. You want to make sure that the pool or the actual jury that ends up sitting there is not biased and it's someone that's going to give you a fair shake.
Exactly. Yeah. So the judge really hits that in before you even get to a point where you're really picking the jury. And then often the judge will ask, does anyone feel like they couldn't be a fair juror from the get-go? Now, sometimes you'll get people who are intentionally trying to get eliminated because they are very excited to be there and they just love being in jury duty, losing money and everything else. I think a lot of people who went to law school find it fascinating. So, we would probably like to be there, but I understand why the general population doesn't feel the same way. Yeah. But anyway, they'll do that as kind of like a screening. And you'll get some jurors who will say stuff they know is going to get them kicked off. Sometimes the judges will bite and they'll kick them. Other times they're like, no, because they know.
It's evident that you're trying to get out of this.
They know they just don't want to be there. But anyway.
But the most important question that I've heard a judge ask is, has your dog stepped on a bee?
Yeah, that is the biggest.
My dog stepped on a bee. We went to the
I think Ms. Heard would agree. That is... game-changing question. But anyway, so once the judge does this, they go through this just kind of opening, explanation to the jury of what they're going to be doing, what the process is like. Then both sides get a chance to basically challenge the jurors, make challenges to the jurors basically that are going to be sitting in the pool. Jurisdictions change depending on where you're at as far as how many jurors ultimately be sitting, depending on what level of offense it is. If it's a misdemeanor, which is here, it's anything, really generally across the board, anything under a year or up to a year is considered a misdemeanor. Felonies, anything a year or more. If that... In the
that warrants
misdemeanors,
a different jury size.
Exactly. And so obviously the less serious charges are generally going to be your misdemeanor charges. Obviously, and the felonies are going to be the more serious offenses. You get more challenges in most jurisdictions in a felony case, but it's the same type of challenges. So you'll get unlimited, what they call for cause challenges. The jurors got to fill out a questionnaire when they get there. And it'll say basic information about them. It'll say their level of education, if they've ever sat, on a jury before. Your
employment history.
Yeah, like that, if they've ever been called to a jury. All types of information.
And just a little parentheses. We're going to include here in the video a copy of the jury questionnaire for this particular juror that we're going to talk about today.
And usually, honestly, they're pretty useless. But the one good thing about them, usually what happens is you would break for lunch after you get these juror questionnaires. Okay? What that allowed you to do is you had about an hour and a half, depending on when you were coming back for the trial or for jury selection to start, which is beginning before trial. We would basically go on social media and look these people up, or try to look them up however you could, because you could find a lot more information on their social media posts than what they're willing to say on a juror questionnaire. Yeah. And especially if it's a certain type of case, in the juror questionnaire would often say like, what are your feelings on law enforcement, or whatever the case may be. Do you think you'd be a fair juror? Of course, everybody usually says yeah, unless they're trying to get kicked. But then you would be able to find some stuff on their social media posts that might not be necessarily grounds to challenge it for cause, but it at least put in your mind, I don't want this person on the jury for whatever reason. Or maybe you do. Maybe you do want that person because that's kind of...
It goes both ways.
Yeah, you're like, this would be a good person because they could understand this.
Yeah.
This topic or whatever the case. It's obviously dependent on the case. But anyway, that brings us back to the actual challenges themselves. For cause is anything that shows that there's bias, basically. If you can show they're biased, unlimited number of challenges. But again, it's hard to really, unless it's somebody trying to get kicked, to get them to admit that. The best way to do it, obviously, and we could go on and on about it, but is to kind of act like you yourself is the attorney that's questioning them. You don't think that basically what you're trying to get them to admit, I guess, in this situation
is a big deal.
Yeah. Because then they feel comfortable.
If you're trying to find out if someone is biased against the police, for example, we're like, man, don't you hate police officers? Aren't they like the worst?
Exactly.
And then you get to be like, yeah, they are. I mean, if you're that easily fooled, and obviously this is an exaggeration for all of you listening. Yeah. But that is kind of what you're talking about. Is the way you try and get them to admit it is by you making it seem like either you agree with that point of view to get them to agree with you. And show their true colors, or make it like, oh, this is a random question coming out of nowhere, no reason, but then you ask the question, they answer it like it's no big deal, and that gives you the information you need.
And for sure, yeah. So obviously if they say something that's clearly shows they're biased, and the judge agrees, and usually if it's pretty clear, if it's to that level, they're going to let you do a for cause challenge. Again, each side gets a limited number of those. And then you have also what's called peremptory challenges. These you can strike anybody almost for any reason. So you could just literally be like, I don't like this guy, essentially, or he said he works at this place, and you don't really even have to get an explanation. The only issue that comes into play is they call them Batson challenges, or it's related to this because the case was called Batson. But you can't strike a juror for specifically based on their race or their gender, and this became an issue, which is what Batson came about because you had prosecutors, especially in one specific jurisdiction, that were continually striking every black juror. Every time, over and over and over. And again, the idea of voir dire is to have a ultimately jury of your peers. And that's supposed to resemble America, our society. So it's not, oh, I'm a white guy, so peers are other white guys. No, right. It's the surrounding, like, America, basically.
The community that you belong to. Yes. And the makeup of that community.
And ideally, is diverse as you can get to an extent, but ultimately we know based on demographics and population of different races and genders and everything else, it's not going to be specifically split down. We got this number of this race, this, gender and everything else. It's whoever gets some. Any reason on a peremptory challenge is fine as long as it's not for that. So you could have prosecutors coming up with the dumbest reasons that literally made no sense to the case. Like, oh, he works at KFC and it's like a OVI or something. It has, a DUI case. And you're like, what does this have to do with anything? But back then they would allow it.
KFC is not a sponsor of this show.
So it was,
but it can be. So hit us up. We're always open to discussion.
But so they started kind of honing in more on that though, to where it's clearly you're intentionally doing this, or you're doing this for other reasons than you're saying you are. That's not acceptable. Other than that, you can strike people for literally any reason. You get unlimited. Well, you get the whatever that is, 3, and the other side will get the same amount to do the same thing. You don't really have to give a good explanation. And so anyway, it's kind of a strategy when you're getting there, because you got to think. You're looking at the questionnaires and you're like, okay, I used these 2 strikes, and then I'm at this person, and I could strike this person because I don't really like this person, but maybe 2 down, there's somebody that's I think is going to be worse, and you don't know how many the other side's going to strike, so it's a gamble. You got to kind of think, well, maybe they'll strike them, but not that. Maybe they'll just use 1, and then you're stuck with that person that's even worse than the person that you wanted to sit in your mind until the jury's actually sat. Like you're going, you could say like
you go back and forth with different.
Yeah, you could be like, hey, juror number 9 said on their questionnaire that they hate police officers, or they think everybody's guilty, whatever that situation is, and strike them for cause out the gate. So it's not like, oh, I'm questioning this person now, because you can go back to juror number 1, ask some questions.
Okay.
You can jump over here. You can go back to juror number 1 after that.
You could go in order. But the fact that you go in order doesn't mean that you can't go back and
you
ask
honestly,
questions until they actually set.
It's better, really, as a strategy, kind of just to bounce all around, because you want to hear everybody's input. You want everybody to get everybody talking.
Right.
That's the biggest part that's kind of hard in jury selection, is getting people to talk, because people they're nervous. They're in a weird environment. They don't know anybody. Now, when you say I'm good, and then the prosecutor starts doing theirs, and you're stuck. You can't say, oh, never mind. He only used 2, and I this is the one I'm worried about. Let me go ahead and do another one. No. Now, if they say something during the other party, they say something, a juror says something that's an issue, and the prosecutor doesn't kick them, you absolutely can say, Judge, I want to kick them for cause because they said this, and obviously it's a problem. And the prosecutor might be like, well, could you? Because a lot of times what you'll do is they'll try to save it, and they'll be like, well, I mean, you said you hate cops, but do you really hate all cops? Whatever. And then they try to get them to backpedal. Yeah, it's a whole process and a lot of it's strategy, but...
And I guess to an extent, for people who are not attorneys, or people like me who are not litigators, right, who are transactional attorneys, as opposed to a lot of other things that happen in shows like Suits, which will tell you they don't happen like that in real life.
Unfortunately. Or fortunately, I don't know.
When you're looking at this on TV, they are making those considerations and those thought processes in a similar way as you do it in real life.
Absolutely. I'd say a lot of it is in line. The biggest issue that's not, I won't touch on it too much because it's not really directly related to this, but is when you see in the TV shows and whatever it is, and there's all of a sudden this new witness that comes out of nowhere mid-trial and testifies. You bust in the door.
Like they are the ones yelling objection, even though they're not attorneys.
Runs in. They were never disclosed. They were never listed as a witness, and then they're able to sit there and testify. Obviously that doesn't happen. Or discovery. You got evidence that wasn't there. You're bringing in all of a sudden out of nowhere that was never disclosed.
Yeah, pulling something out of your code, like
the dramatic stuff.
We just got this stuff. Yeah.
But you do get the dramatic people lying.
But at least our listeners can now know that voir dire. Hey, that's real. That's real life.
One of the few things that are
it's pretty accurate.
Definitely. Yeah. The idea is to get a fair and impartial jury, right? But really, both sides are trying to pick jurors that they think are going to help their case. So nobody really is looking for that fair and impartiality, unfortunately, except for maybe the judge. But at the end of the day, I think the thought process is, well, if they're picking who they think is going to be good and they're picking who they think is going to be good, it's going to balance itself out.
It balances out where it's impossible because you have a client to represent.
Yeah.
It's impossible for you to be like, oh, I'm going to pick the fairest juror ever. But if I get 3 challenges, you get 3 challenges.
Because your job
is... 4, you get 4.
Yes, to do what's in your client's best interest.
In theory, balance itself out. Anyway, so I think that was a good, thorough walkthrough of voir dire process. So now that we discussed this, then let's talk about this motion that Amber Heard's lawyers filed.
Yeah.
And again, they filed it for a mistrial because they said Juror 15 was not supposed to be there. They say a jury summons was sent out, and this jury summons had the name of a person at certain address, their certain name, and a date of birth. And that's going to come in handy when we discuss this a little bit later. But they said those 3 pieces of information were part of the summons. And they claim, well, this person that the summons went out to was supposed to have been born in the 40s, in like I think 1945. So they were supposed to be right now in their 70s, right? Like 70 years old or something.
77, I believe, yeah.
77, there you go. So, but the person that showed up as Juror 15 had their same name, lived in the same address, but they were born in 1970.
Yeah, they were in the 45 or in the.
They were 52. 52.
Oh, that's right.
Yeah, so 1970.
Yeah.
So, essentially, this person's son.
Yeah.
Right?
Yeah.
It has the same name, lived in the same address, but the date of birth was different.
Which is kind of crazy if you think
Yeah,
about it. Like,
exactly. You have to think about it.
But
then also, if you think about it, it's like, then the theories kind of start flying. Did the juror that actually sat know, hey, this is for my dad, but I should just do it?
As Hurd's attorney.
As Hurd's attorneys argue, because they say that
yeah.
in Virginia, the process of jury selection includes what they call safeguards to make sure that you are who you say you are, and you are the person that actually got the summons. And they say that you go into a website, you type in your juror number that is included in the summons, and then you enter the demographic information.
So this person lied, allegedly.
Right. They were saying that this person lied because they said, again, the summons had the date of birth, and this person went in and entered their name, their address, but their dad's date of birth, so that it wouldn't flag in the system that it was wrong, that it was the wrong person. Again, this is all what they're claiming.
Yeah.
Then in their mind, this person showed up, got selected, and then sat for a 7-week trial, rendered a verdict with the rest of the jury that resulted in Amber Heard, owing like $10 million, I think, in the end.
Yeah, it's like a
$10 or $8 million.
Catch Me If You Can, episode.
Exactly. Yeah. and they're saying, you know what? Because this juror should not have been there in the first place, and they deceived the system by sitting there instead of sending their dad, Amber Heard was deprived of due process.
Yeah.
And, Your Honor, that necessitates a new trial.
Yeah.
Their motion is like 3 pages long.
Yeah.
And they said, Your Honor, the juror 15 got a summons. It had this information. They must have entered it, with intent to deceive. They sat here. They were not supposed to sit here. Amber Heard was that was unfair. She didn't get due process.
Absolutely.
We should have a new trial.
Yeah.
And we'll talk about right now. We'll talk about really what can be cause for a mistrial. But in this case, they're saying we need a new trial because that person wasn't supposed to be there.
Yeah.
The defense submits a memorandum, and that one was a lot longer. That they did their homework.
Yeah, and that's basically the response, right?
Right, it's a response saying, "Hey, you said X, Y, Z.
Now
let us tell you, Your Honor, let us tell you why they're wrong."
Yeah.
And in that memo, though, the bottom line is, 1, there was no lack of due process. For God's sake, we sat down there for 7 weeks going back and forth. And so you had your day in court.
Had that jury selection process we talked about.
You had the voir dire to ask all these questions. And essentially you had 7 weeks to bring this up. You only bring it up after you're now owed, or you're asked to pay, as Amber Heard, between $8 and $10 million.
And if she won, would she have brought this up?
Exactly. And there's other things that we're going to talk about just after we finish going through the context, right? Yeah. But that was now the issue that we have at hand. Then let's talk about a motion for mistrial very briefly, what it is and what it means, and in which cases it makes sense. A motion for mistrial is simply, essentially, an attorney's plea to a court saying, "Hey, do over.
Yeah,
let's do it again."
Yeah,
but because that is what it implicates, it means
the
all the time
remedy.
we spent, the time we spent, all the money you already paid, because you have to pay your attorneys, you have to pay court fees, filing fees, everything. All the time, all the people's time, because the people that sat on the jury too, you can't use the same people anymore. That means you have to essentially restart everything, get another jury pool, get another jury sat, get new motions, probably a new judge too, a bunch of different things. It's such an extreme measure.
Well,
that is a last resort.
Very
measure.
What makes it even more ridiculous in this situation is, since this was so high profile, this was all over the media.
Oh yeah.
Every channel was talking about it. Every news channel was talking about it. It's all over social media. It's not like you can just go back to Virginia and pull more jurors and have them sit. and
that don't have an opinion already.
Absolutely.
Yeah.
So it's like, and then you can only move localities and so much for them to still have jurisdiction. It's not like you can go to. It's not unless it's a federal crime. You can't go to another state to hear the case if Virginia has jurisdiction.
And this had nationwide, even if I dare say, like international repercussions, or like it echoed throughout various countries, not just the U.S.
Absolutely,
where you had memes being created in Mexico, Canada, not only in the Americas but also in Europe, because there were so many like sound bites that were just like hilarious.
And Mr. Depp was trying to urinate in the foyer, wasn't he? No. Mr. Depp had his.
But a motion for mistrial is a last resort, and which was it's a big ask.
Absolutely,
it's a big ask for all the reasons we just mentioned. And like you said, it's not only that, but now it's going to be hard for us to pull a jury.
Even if we did that, how is that going to change?
The arguments you had already were used. They were already exposed. People already heard them, and they formed their own opinions. Mm-hmm. Now, good luck finding someone who, at one point in time, did not get embroiled in the whole, Hurt Depp trial. Yeah. And hasn't already formed an opinion.
And we know from the, working for the Innocence Project and everything else that like how hard it is even with criminal cases to get a new trial.
Absolutely.
Even if you have now, and we'll get into that at a later time, but even if you have evidence showing somebody's innocent, that's not enough at times. So what they're asking here, and based on, the lack of information that we will get into, it's like, it's just absolutely absurd.
Yeah,
it is.
Absurd. And well, then let's talk about, because you said, based on the lack of information, it doesn't make sense. Let's see when it does make sense to have a mistrial, and because again, this is a resource of last resort. Yeah. There's only certain things that can get you to that threshold. Misconduct by the court, misconduct by the jury, and that is really the more relevant one. We'll dive into it a little bit more. The parties or the witnesses engaging in improper conduct, like you have ex parte conversations with a juror or a witness, or even the court, right? Maybe not a witness, because a witness is usually your witness. You present it. Yeah. But an ex parte just means you are talking to the judge, for example, without the other party being present. That's what it means. So these types higher intentional misconduct, or even like grossly negligent, if we want to get to that point, only that gets you to that bar. The only one of those different scenarios that could potentially come into play is jury misconduct. Mm-hmm. And within jury misconduct, you have or jury related conduct. It could be jury misconduct, but where a juror goes and talks to another juror without being permitted to do so, or where a juror goes and talks to people about the case, when they're supposed to be sequestered or under a gag order, where you have maybe not the right number of jurors, or there's an inconsistent verdict, and these highly prejudicial is what it is, because again, a mistrial is essentially saying there was injustice. This was not justice. My client did not get their day in court the way they should have. They did not get due process. So in order for that to happen, that means there has to be something grossly wrong with it. Exactly. That really warrants, you know what?
That made the trial unfair.
Yeah, it was unfair. We need to get a new trial going on. And then that happens. Yep. On top of that, which is what's going to be interesting when we talk about the judge's order, we know as attorneys, even if you have something that the judge is not going to like, or you don't have a lot of evidence right now, or the evidence is not going to be admissible in this particular case, in order for you to be able to raise it on appeal, you need to raise the objection now. Even if you get it denied, at least it's on the record. Exactly. And that is what we call, raising it to preserve it. So they didn't do that because, again, they filed this motion after the trial was done. And two, it needs to be timely. Yeah. And there's no set time where you need to do it. It needs to be, a day or within a certain number of days that the trial started. Yeah. But when you find out, yes, you need to then submit that motion. And what you and I were discussing when we first heard this was, wait, so you would think that you would hope that they are not sitting on this throughout the whole trial. Yeah. But even if they find out after the trial, what prompted them to say, hey, let's look at to see if any of the jurors that were sat
Exactly.
are not who they say they were,
Yes.
you know?
Unless you had an inclination early on that was an issue and you just didn't bring it up.
And if you didn't bring it up,
That's the issue. Exactly.
Yeah.
Why did you wait? You shouldn't have obviously waited. And what's more interesting to hear too is like, not only did they wait until after the trial, they wait until the judge originally entered her judgment as well. It's like they had a lot of opportunities if this were an issue. But yeah, and the judge almost kind of insinuates, and to an extent that like, because it certainly seems like this was something that is had in their back pocket waiting in case the trial didn't go in their favor.
yeah. The timing itself is really sus.
Exactly.
And now, in all fairness, though, if you just read their motion,
Yeah.
you'll be like, "Oh my god!"
Oh yeah.
If there's really a date of birth in there,
Yeah.
and the person, in order to certify or essentially check in as a juror,
Live.
they entered their parents, their dad's date of birth. Well, that sounds like it's intentional. Like this juror wanted to be sad
And, yeah.
because they wanted to be a part of the case. But
And the question
as
is
you
why,
know,
too,
yeah,
right?
exactly. The question is why, because as you know, you don't get told what case you're going to be on or what case you're being summoned for.
You don't know anything.
Yeah. They said, well, Your Honor, this case was highly publicized in the date and the court. Well, yeah, but you still don't know. There's
No.
plenty of, like, every day, and you know this better than a lot of
Yes.
people, you know that every day you have tons and
Yes.
tons and tons of cases the same day in the same court that are not related to each other.
Criminal and civil.
Yeah, both. Exactly.
So it's not you don't know anything. You show up, you sit in a room, they tell you, okay, here's where you're going. Half the time you don't even know what's going on. You get an inclination of what's going on through voir dire.
Based on the question.
Based on the question, maybe, but sometimes you don't know until that opening statement when trial starts. So there's no way.
The client said,
no
like,
way.
Johnny was not there and Amber was
Yes.
not there, just their
There's
lawyers.
no way
You
they
don't know who
knew.
they are. They're asking you random questions, and there's no way for you to know. So the question then, why would this person lie to be, unless they just love jury duty, why would they lie, right? But again, if you just read the motion, you're like, this person was, something fishy was going on.
Yeah.
Then when you read the order, and that's to your point, the judge is like, okay, let's set the facts straight. Let's get this stuff straight.
Yeah.
One, the summon goes out. It doesn't have a date of birth.
Yeah.
It doesn't include one.
Yeah. Just a name and address. which
Exactly. Name and address, which is obviously what you would
They
expect.
both live at.
Yeah. And then once that's the case, it's I don't think it's unreasonable for the person to assume, oh, I guess that's me. I don't think that's my dad.
Yeah.
My dad is in his late 70s.
Yeah.
I doubt they want him to serve. Not that elderly people can't, but I don't think it's an unreasonable conclusion for that person to have said, this is probably me.
Yeah, no. Nor is it on them to call and clarify.
Yeah.
It's just got a name and address.
Exactly.
Okay. Like, that's not on the juror.
Here I am. This is my name. This is my address. So that is one thing that the court says. And then the other thing is the juror, and we'll include this on the screen if you're watching the video. The juror filled out his jury questionnaire as himself with his information, with his date of birth, with his employment history and his answers. Again, giving credibility to a conclusion that he thought, this is me. Like, I'm not trying to fool anybody,
Exactly. There was this whole nefarious, underlying assumption or whatever was clearly not the case.
If you are a mastermind and you're like, you know what, to validate myself as my dad, I'm gonna put in his information, but on the questionnaire, I'll put mine. In the order, the judge again reiterates voir dire is the purpose of it is to obtain a fair and impartial jury. And nothing you gave us, meaning the Amber Heard's lawyers, shows there was fraud or wrongdoing or injustice. Yeah. You essentially what we were talking about. You had every opportunity to object to it. Yeah. Yeah. Why did you object to it after the fact? Why didn't you do it during voir dire? Yeah. Throughout the 7 weeks of the case, but not until after everything seems lost.
Exactly, because Heard's attorney had the same juror questionnaire, as did Depp's. Obviously, they presumably reviewed that, or at least should have. Juror 15, who allegedly masterminded this whole thing to sit on the trial he wasn't supposed to be on, sat through the same jury selection as everybody else. Heard's attorneys had the same opportunity to question him and kick him off if they felt that he wasn't fair and impartial. Clearly they didn't. Yeah, and then they waited until the entire trial was over. Then the judgment was entered. Then they're like, you know what? This is a problem. And this was so bad. Not only was it a problem, but it was so prejudicial that we need a new trial. Or, we need to declare a mistrial. The judge to declare a mistrial. And it's just, the entire thing is...
It's like you have the opportunity to choose an umpire.
Yeah.
And you go through a process and you're like, all right, that umpire, that'll do.
Yeah.
And then you go to the game and you lose and you're like, that umpire was, corrupt.
Yeah.
What's going on? That game was rigged.
Yeah.
The umpire had it against me the whole time.
Yeah.
Unfair. And it's like, no, you can cry on unfairness now.
No, and then we like, as you know too, like anytime you're even in trial, something comes up that you think is an issue, you object to they preserve it for the record. Basically,
Absolutely.
To preserve it for appeal. If you don't object in trial, you can't then later argue, well, except the extreme circumstances, you can't later argue that, that you were prejudiced because you didn't bring it up in trial when it was that issue, when it could have been addressed. And that's the same thing that happened here. They completely wait until everything is over, and then they're like, "Oh no, this didn't go in our favor."
Oh my God,
injustice!
Yeah, exactly. You can't cry injustice just out of the blue when you decided to presumably sit on this information for who knows how long. And now, because that I think brings up the question of the timing that you and I were discussing earlier. If the summons didn't have a date of birth, how did Amber Heard's lawyers knew if they can actually know that, because they may be just making it up, if they know that that person was not supposed to be the right juror, it was supposed to be someone born in 1945, at what point do they actually then get the information that shows, okay, here now there's a date of birth, and then you have then a chance, at that point, once you get that information, it's fair game. Because you could then review and be like, okay, juror 1, juror... Hey, juror 15 says it was born 1945. He looks great for being born 1945,
right?
For being 77. Right? At one point in time, did you actually get this information, if you even do get it during trial?
Well, that was it.
And if you don't, goes back to our earlier point, what prompted you to then look this information up?
Yes. And we don't even know now, even after the decision, whether or not that was the wrong juror.
Yeah.
We just know they're saying it was the wrong juror. It could have very well been for the son. And like you said, if they did have that information, why wasn't it disclosed? But also, even then, like we were just talking about, what prompted them to specifically look up juror number 15 and who was summoned and what their age was and this, that, or whatever. Like, that doesn't
even
make
if you look
sense.
at the whole jury. Yeah. That is a very specific thing to look out for.
Absolutely.
Hey, let's see if, we lost this trial. Our client owes $8 million. I think it was like 10, but then she got like 2 back. Yeah. It just kind of like offsets.
Balanced out.
Hey, our client just owes $8 million. Let's see if all the jurors were who they say they were.
Exactly.
That is a very niche thing to pick out, as opposed to be like, let's see if there was any misconduct.
Yes.
Let's see if there was any evidence that we weren't allowed to bring in, that we objected to preserve it for the record so we can then appeal. No. It's like, let's look at the jurors.
Yes. Yeah. Which, again, suggests that
how many times do you think that happens in real life?
Exactly. They knew about this while the trial was going on, and they didn't bring it up.
And that is the presumption, right? That there must have been some indicia that something was going on for them to then turn their eyes there and just act like, oh, we just looked at it right now, and we just found it right now.
And you can tell the judge is getting annoyed. I mean, the initial judgment, on, was it June 24th? She said in all caps, like, this is the final order. Like, bold, all caps. Basically saying, I'm done with this. We sat through this for like 8 weeks or whatever it's been, 7, 8 weeks. Heard all this stuff. It's gotten drug out. And then they bring this very great motion on the merits that's, laughable. Yeah. Especially once you see what they're actually alleging, what they're basing it on. And it seems to upset the judge even more. Which this time puts in all bold, this order is final. As well at the bottom.
Yeah.
So, it's
And you got to think also, I don't believe Amber Heard's lawyers are not good lawyers.
Yeah, no.
I believe Johnny Depp's lawyers were fantastic lawyers, right? But I don't believe that Amber Heard's lawyers were not competent.
Good.
So...
Not as good as me, but
absolutely, yeah. Or me, even though I don't litigate, I could probably do a better job because attorney. No, but where I'm going with this is, if you look at the motion and then you look at the response of the court,
Yeah.
say they didn't do their homework.
Yeah.
Because the court says, listen, I'm gonna entertain just for a second that you well, two things. One, that you just found out about this, or that you knew about it, you know, that we provided you that information and you knew about it before.
Yeah.
In either case, if there's any irregularity in the information that is related to a jury, it's your responsibility to find errors in it
Yes.
and object to them then and there.
Yeah.
And then what's even more interesting is, if you do find an error and you need to object to it, there's a way to do it. There's a specific procedure to do it that is delineated in the statute.
Absolutely.
And they didn't do that.
Nope.
That's strike number 2. So 1 is your responsibility to know this information, to review it and make sure it's accurate. Strike 1, because they didn't do it, at least not when they got that information.
Yeah.
Strike 2 is, if you do find that, you need to object in a specific form. And that's one thing that people that are not familiar with the procedures, right? Civil procedure and how you're supposed to file motions and enter complaints and whatnot. The law sometimes is ridiculous, and you have guidelines as to, if you're gonna say this, you gotta say it in this way within a certain number of days to this person. You have to also provide a copy to so and so. There's procedures, and that's why that is important.
Yeah.
They say, the statute says you need to do it in this way. If you don't do it in this way, it doesn't count.
And
And number 3, strike 3, the judge says, even if you had done it right and you just found out the information, the statute, a separate part of it, explicitly says an error in that is related to the jury, right?
Yeah.
It's not grounds for mistrial,
Yes.
because mistrial is
Yes.
such a high
Yes.
bar. This is not it.
Yeah, and that's it. At no point do they say this is the wrong juror. The wrong juror sat there, and then let's take everything they said as true. He nefariously was like, "Oh, I'm this guy, you know,
I'm
to
gonna
sit in
sneak
for
into
his
this
dad,"
case
because he wanted to be on there for whatever reason. You didn't show prejudice, even if that happened. Even if we believed all of this stuff, which we know is not the case, but even if we were to assume everything they said was true, that's no prejudice was ever shown. So it doesn't mean there wasn't a fair trial. Certainly not grounds for mistrial.
Yeah.
Yeah.
Well, 1, because there's no prejudice shown.
Exactly.
Period. And 2, because the statute explicitly says.
Exactly.
And this, it's hard to find a statute that is on point to what you're arguing.
Yeah.
And when the statute
Better
literally
than
says,
this.
hey, what you're trying to ask the court to do is literally prohibited by the legislature.
Exactly.
It's like, what are you doing? And I can understand the concept of a Hail Mary.
Yeah.
But even a Hail Mary, you try to stick everything at the wall. But even for that reason, you do it the right way.
Exactly.
So that the reason why the Hail Mary doesn't stick is not because of procedure, but it's because the court was like, nah, good try, good effort. That's not it. Yep. No, they were doing everything wrong.
Yeah. I think it would be more understandable, kind of what we were talking about before, like, not understandable, but because you have a duty as an attorney. But if these were new attorneys, you know, maybe like, whatever. Maybe they don't know, they're sort of practicing this, that, or whatever on some of this stuff. But it's like, Amber Heard has a lot of money, and these are very expensive attorneys. These aren't new attorneys.
Yeah.
So they have a ton of experience, and it makes this even worse because it makes it look like what they were doing. They knew what they were doing. It was very intentional, and it was basically misleading the court.
Yeah.
In a lot of ways. And it's something that clearly seems, at least, if anybody was being shady, it wasn't juror number 15, but it was Amber Heard's attorney.
Yeah, at least not in the court's eyes.
Yes.
So this was just, I mean, obviously the order is already out. It doesn't surprise us. I think the court order is also like, I think maybe like 5 pages.
Yeah, it's very easy, very quick.
Very digestible, and we can put a link to it in the description of the video if you guys want to read it. But the court does a great job of saying, listen, because of this reason, this is the final order. Come on. Like, good effort, but actually not good effort. You know, this is not how you do this. And there was a footnote, actually, that I thought was interesting in the order where the court cites a different case where I believe it's 2 felons sat on a jury. And obviously you would think, you know, well, there's a lot more implications when it's someone who has been through the judicial, through the correction system, right? And in that case, even in that case, the court said, hey, we're not saying there's not a possibility of prejudice by having 2 felons sit on a jury. But even the possibility of prejudice at this level with those 2 felons does not satisfy the requirements
Exactly.
necessary to show probable injustice.
Yes.
Meaning even that does not get to the level that you need to even be considered for a mistrial.
Yes. Meanwhile, here we have just a ton of speculation.
Yeah.
We don't even know. Again, that was the wrong juror.
And there was
So it's like-
and there was no evidence of prejudice,
Yeah.
but also no evidence of what you were saying is true.
That didn't even happen.
Because the court, I don't think the court is like, I'm gonna lie and say that they don't have dates of birth.
Yeah.
Well, no, the court's gotta know if they have dates of birth or not. In the
Absolutely.
summons. So
It's insane.
it's no
But
surprise to anybody. But I just, I thought it
some
was
comedy in it.
really funny. Obviously, you thought it was really funny when
Yeah.
talking about this. And I mean, who knows? This says it was a final order, but
Yeah. Well, I
Amber
think
has
they're
been
gonna
trying
appeal.
to. I've been trying to.
Yeah.
Obviously, there was an appeal, and the judge was like, "Sure, I'll give you one, but you have to put all the money up front because if you lose, we don't want to have to go through this again, right?"
Exactly.
And then now there's motion for mistrial. Not surprising they denied it.
Yeah.
We'll see what happens next.
Yeah.
It's
It's,
just-
it's certainly interesting.
we thought it was something that had an opportunity for a couple of discussions of some concepts that you may not be familiar with,
Yeah.
and that we could hopefully break down in a way that's digestible. And now in the future, when you look at celebrity cases, you're like, oh, I know what
Yeah.
that process is. I know what this is.
It's slightly
And-
entertaining, hopefully.
Yeah, absolutely.
But if nothing else, it shows you how not to be an attorney. I think
If you are an attorney, you can learn from these mistakes.
Yeah.
Because hey, listen, we're all flawed and people make mistakes. But even to your point about even if these were younger attorneys, we've seen this ourselves. Usually, younger attorneys are even more prepared.
Yeah.
Because you're young, you're nervous, you want to be over prepared.
Yeah.
And it's usually the older attorneys that have been doing this for
Yes.
years and years and years. To them, it's like going through the motions that then may have some of these like things fall through the cracks.
Yeah.
But even then, if you're a seasoned attorney in Virginia that is trying to submit motions for mistrial, you know the proper way to submit motions for mistrial.
Yes. Yeah.
And you know
that's
what
it.
you need to argue. You probably even have a template on your computer
You should.
that you just fill in the blanks.
And it's not like this was a statute that just passed yesterday or something
Right.
where it was like, okay, maybe they're just
Yeah.
relying on what they knew. So I think ultimately, obviously this is my assumption, but she was probably paying him a ton of money, and they were like, well, this is an argument we can make, and we can get paid even more money. So I think that's ultimately why they probably did it, but who knows?
It is one of
You know?
those when maybe you're throwing everything at
Yeah.
everything in the kitchen sink at the wall and see what sticks and
And maybe
yeah.
she pushed them. She's the client, so who knows?
And that's
But-
true. One thing that we should make clear is, when you're an attorney, as much as you may see it on TV, where it's different to our earlier point, your client is the ultimate decider. Except for cases when the client is asking you to commit a crime.
Yes.
You don't.
Or-
you have that latitude, obviously.
You're not supposed to bring frivolous lawsuits, which,
Right.
obviously if you know there's no... But there was an argument to be had here.
Because if it's true that the juror was a different juror,
Yes.
there's an argument. You did not present that argument well.
You did not.
But there wasn't.
You had zero evidence to
So at
support any
least,
of it. But...
at least it clears the frivolous bar.
Yes.
Barely.
Yeah.
But again, to your point, maybe Amber was like, you know what? I want you to argue everything and anything you can find in the Sun.
Yeah.
And the
It's
customer
something.
is king in this case.
Yeah.
So-
Who knows?
Well,
But
It was definitely interesting. We hope you find it interesting
Absolutely.
as well. We hope you can laugh with us about this while we're drinking some also not sponsored Johnny Walker. Just to keep a nice light mood. Do you have anything else to say, Jeff, before we say goodbye for episode 2?
no. Like I said, just if anybody's interested in going to law school or becoming an attorney or is practicing attorney, I think this is a good case to, just take in and think about maybe what you shouldn't do or at least doing your homework before you file your motion.
Yeah.
If nothing else.
It's a cautionary tale. And, for those who are interested in even if you're not interested in going to law school, but are interested in just what happens in courtrooms and whatnot, I feel like this was a good one, a good case where the motion from Amber Heard's attorneys was really short.
Yes.
The memorandum was a little bit longer, but was also, I think, well written, well drafted. And then the order from the judge was also pretty short.
Absolutely.
So if you're just curious about, hey, what do these documents look like? I'll put the links in the description, and you can read them if you want to. You don't have to. We try to do that work for you, so you don't really have to.
Yeah, I do. I think a lot of people might find it interesting to actually read it. It certainly was for me. So, yeah.
All right. Well, thank you again for sticking with us. We'll see you in the next one. This was Lodge.